Hello, this is Janette Levey Frisch. I am an employer's lawyer, and I use my knowledge of employment law to work with employers like you to help you craft appropriate, creative, and proactive solutions to the different challenges you encounter in your workplace. We are back now for the 4th episode of Ask the Employer's Lawyer. Woohoo! So in Ask the Employer's Lawyer, for those of you who are just joining us, every week I answer one question commonly asked by employers, or maybe even one that's asked by you, or a similar question that you have had. These questions are based on federal employment laws and general legal principles as opposed to specific state laws. Now, to get some of that other housekeeping out of the way that I usually do at the very beginning, we have a disclaimer. That's the term in legalese. So here it is. Answers to questions are not legal advice. They do not, repeat not, create an attorney-client relationship, nor does listening to these videos or these shows or whatever you want to call them. They do not replace consultation with your friendly local employment counsel. So I still recommend you do that with the very specific questions and concerns you have, but hopefully you can get something useful out of these videos as well. Okay, let's get to our question for the week. This week's question comes from Emma the employer. So Emma asks the following. An employee of mine recently went out on FMLA leave. She is about to exhaust her entire FMLA leave time. Okay, so for those of you who are not familiar, that means that she is about to use up 12 weeks of FMLA leave time, because FMLA leave provides 12 weeks unpaid job protected leave. Okay, she's about to exhaust her 12 weeks, and it sounds like she's telling me that she's not going to be able to come back yet because she is not 100%, she's not entirely healed. What do I do? Do I require her to come back or lose her job? Do I require her to be 100% healed before she comes back? Can I fire her? What are my options? Thank you, Emma, for your question. This is a bit of a multifaceted question. And as with anything involving employee leave and FMLA specifically, it's very nuanced. So if you are feeling a little bit at odds here, at a loss, if it's any consolation, you're not alone. All right, now let's dive into the answer here. So if you have an employee, if like Emma, you have an employee that is not sure that she can come back from leave, or maybe is not going to be 100% healed after the 12 weeks of an FMLA leave, one thing you can't do is tell an employee you must be 100% healed, or you probably cannot do that. First of all, the employee's health condition, the one that triggered the need for leave in the first place, might also be a disability under the ADA. That's the Americans with Disabilities Act. And I'm also including in that the Americans with Disabilities Act Amendments Act. Just going to refer to that collectively as the ADA. So if your employee has a condition that could qualify as a disability under the ADA, and there's a good chance it does, because the definition of disability under the ADA is very broad and very inclusive. If that's the case, this employee is probably going to be entitled to a reasonable accommodation of that disability. Now, that may be in the form of some type of return to work accommodation, maybe some kind of temporary modification to job functions or schedule, or a temporary reassignment or something like that. So the point is, generally speaking, you can't require an employee to come back at 100% healed without risking liability for a violation of the ADA. So what can you do? Well, you can then do what's known as engage in the interactive process with the employee. So you have a discussion about the employee's condition and what the needs and limitations are, and you see if you can come up with something that would enable the employee to come back to work do most of his or her or all of his or her essential job functions with an accommodation that is reasonable. Now, how do we know if an accommodation is reasonable? Specific circumstances. You have to do an individualized assessment there. Now, the other possibility is maybe the employee still really can't come back to work. So you may be thinking, well, wait a minute. This employee got everything she's entitled to, 12 weeks of FMLA leave. That's it, they're done. I don't have to keep the job open for this employee, do I? Well, extended leave may be a reasonable accommodation under the ADA, so yes, you might have to do that as well, or alternatively, or whatever. So that may well be something that you have to do. So the point is that you cannot just assume that because an employee is about to exhaust their 12 weeks of FMLA leave, that that's it and they're done and that you have no further obligations. In fact, under the ADA, you might have additional obligations. Now, the only time that you might not have additional obligations would be if you can show that there is no reasonable accommodation available to that employee and that the employee in his or her present condition cannot perform his or her essential job function safely. And you would need some documentation that would show that. It's not enough to simply say that. So, as you can see, the answer is nuanced, the question was nuanced, the situation is nuanced, and you know what that means you need to do. If you are not the HR director, manager, or whatever, then you should consult with your HR department or manager or whatever, assuming you have an HR department. Now, if you don't, or if this is something where HR isn't quite so sure what to do either, if you have in-house counsel, you consult your in-house counsel. So what if you don't have in-house counsel? You know what my answer to that's going to be, right? No. You're going to consult with your friendly employment counsel. No, it doesn't have to be me, especially if you want to look for somebody who is licensed in the state or states where your employees work. Hope this clears a few things up for you. If you like this video, well, you hopefully know what to do by now if you've been here before. So take that cursor, move it over around here and give it a thumbs up. And then move along over there roughly and hit that subscribe button and ring the bell. And of course, share the love by passing this video on to your friends and colleagues. Finally, do you have a question that you would like to ask the employer's lawyer? Let me know in the comments section below, or using my contact information that follows directly after this video, call me or email me. For now, this is Janette Levey Frisch signing off from Ask the Employer's Lawyer. Come on back next week for our next episode. See you then.